Millions of international travel arrangements are executed daily through massive digital platforms. The consumer clicks a button, money leaves their account, and the platform promises a frictionless transition from their living room to a premium destination. But the digital interface is a highly curated facade. When a traveler named Quentin arrived in Koh Lanta, Thailand, to check into a property listed by Agoda as the Dream Team Beach Resort, the digital promise immediately collapsed. This photograph shows the actual reception area of the resort upon his arrival. The facility was entirely closed, unstaffed, and abandoned. Left stranded on an island with limited infrastructure, Quentin was confronted by an unaffiliated local resident who managed the physical property, but refused to honor the Agoda contract. The traveler was subjected to verbal hostility and forced into an illegal status under Thai law, which requires tourists to register their lodging with the police. This image shows the interior condition of the facility. The mattresses were torn, stained, and entirely unsanitary. The physical product did not exist in any usable or safe capacity. Consumers place their financial trust in the global, multi-billion-dollar brand of the platform. However, the localized execution of that service is frequently unverified, leaving the consumer absorbing the physical and financial risk of the platform's inventory. This document is the official booking confirmation. It clearly lists Agoda Company Pte Ltd as the entity that booked and collected the payment of €438. The transaction occurred entirely within Agoda's financial ecosystem. Under Article L213-1 of the French Consumer Code, a professional entity is legally required to deliver a good or service that strictly conforms to the description provided at the point of sale. This diagram illustrates the platform's primary legal defense. An OTA, or online travel agency, collects the funds directly, but the moment a service failure occurs, the platform shifts its identity. It claims to be a mere intermediary, a neutral software pipeline with zero liability for the physical hotel. It operates as an aggressive merchant of record to secure your capital, but vanishes into a passive intermediary status the moment you demand accountability. Agoda's refusal to assist Quentin represents a calculated application of a legal architecture designed to bypass European consumer protection mandates. European consumer law explicitly identifies and prohibits contractual stipulations, known as clauses abusives, or unfair terms. These are clauses embedded in contracts that create a severe imbalance of rights to the detriment of the consumer. While Agoda heavily markets itself as a global booking leader, its affiliate agreements and terms of service are meticulously drafted to isolate the company from the physical execution of the travel they sell. This animation maps out a specific black clause hidden in their terms. To formally resolve a conflict, Agoda attempts to force European consumers to send physical mail to their corporate headquarters in Singapore. This engineered geographic friction directly violates Article R212-1 of the French Consumer Code. It establishes a massive bureaucratic wall that makes pursuing minor claims mathematically and logistically irrational for the user. The platform actively solicits customers in France, processing transactions in euros, yet it utilizes a jurisdictional void to enforce foreign rules when it is financially advantageous. These terms of service are not designed to clarify operations. They are weaponized to engineer a complete break in the chain of legal accountability. This is a formal dispute form from N26 Bank. When merchants refuse a refund, consumers rely on a bank chargeback, a financial mechanism to forcibly reverse a transaction. Quentin filed under Reason Code 4853. Code 4853 is specifically designated for services that were paid for but never rendered. He submitted this dispute to his bank, N26, expecting a straightforward recovery of his €438 based on the fact the hotel was closed. In his initial panicked email to Agoda while stranded, Quentin, whose native language is French, used the English phrase check-in to describe arriving on the island, rather than the act of registering at the hotel desk. This email from N26 shows the exact evidence Agoda provided to fight the chargeback. The platform isolated that single semantic error, the use of the word check-in, and submitted it to the bank as definitive, written proof that Quentin had consumed the service. Retail banks process thousands of these disputes daily through automated systems. The algorithms rely almost entirely on the documentation provided by the merchant. The bank rejected the consumer's claim. This screenshot shows Quentin's follow-up communication to N26. It highlights a critical omission by Agoda. They deliberately withheld the log of a subsequent 21-minute phone call where Quentin explicitly clarified that no check-in occurred and that the hotel was completely inaccessible. The consumer is left writing desperate emails to a blind banking algorithm, trying to inject context into a system that only recognizes the highly curated data packet submitted by the corporation. Financial arbitration assumes both parties have equal footing, but platforms maintain absolute monopoly over the communication logs. They can selectively omit or weaponize data to easily manipulate banking algorithms and win financial disputes. The modern dispute resolution system suffers from severe data asymmetry. The consumer operates in the light, while the platform observes from behind a one-way mirror. Quentin's panicked messages sent to Agoda's customer service in a moment of distress were immediately repurposed. Instead of triggering a support response, his data was packaged and deployed as evidence against his financial claim. Agoda's privacy policies explicitly outline their right to receive and transmit user information to third parties. They justify this data sharing under the broad, vaguely defined umbrella of fraud prevention. During this specific dispute, the internal data handling was so reckless that Agoda's system generated links which exposed the personal data of a completely different, unrelated user to Quentin. To even initiate contact with customer service, the platform forces users to authenticate themselves through highly trackable links and virtual assistants. You cannot seek emergency help without surrendering more behavioral data. This strips the consumer of autonomy, leveraging their immediate, real-world distress to feed the platform's internal tracking metrics. In the platform economy, personal data has transitioned into financial ammunition, weaponized to defeat the user during legal and financial arbitration. Even in the rare instances where a platform acknowledges a total failure of service, they employ one final architectural barrier to prevent capital from leaving their system. Instead of refunding fiat currency to a credit card, platforms issue compensation in proprietary digital tokens, in this case, Agoda Cash. This diagram illustrates the function of platform tokens. They operate as an unregulated shadow financial product. Real euros are absorbed by the company, and the consumer is handed a closed-loop voucher. This mechanism permanently prevents actual, usable capital from returning to the consumer's bank account. To realize any value from the refund, the user is forced into a secondary transaction on the exact same platform that failed them. The corporate math is highly advantageous. Agoda retains the actual fiat currency on their balance sheet, bypassing standard banking regulations, reserve requirements, and credit laws. These proprietary digital currencies do exactly what they are engineered to do: mask true merchant liability and trap consumer capital within a closed corporate ecosystem. The reality of Quentin's experience on the island of Koh Lanta was the predictable result of a highly optimized corporate architecture. The platform relies on 4 interlocking pillars: contract evasion to deny responsibility, evidence falsification to win banking disputes, data weaponization to monitor the consumer, and shadow finance to trap capital. This creates a massive structural disadvantage. Consumers, and even retail partner banks like N26, operate entirely blind to the platform's internal mechanisms. The retail banking sector faces a severe threat. Automated chargeback algorithms lack the capacity to cross-examine selectively curated, asymmetrical evidence provided by an online travel agency. As long as digital platforms maintain absolute, unchecked control over the point of sale, the communication channels, and the dispute evidence, true legal accountability is mathematically impossible. Current consumer protection laws are obsolete. Regulatory bodies and fintech compliance officers are attempting to police a 21st century data architecture with 20th century legal definitions. We require aggressive, external, and mandatory audits of the internal data handling and arbitration practices of these intermediaries. Regulators must pierce the intermediary veil. Until they do, the integrity of the entire financial dispute resolution system remains entirely compromised by the platforms that control the data.